Yes, good morning, everyone. My name is Kalia Parrish. I'm with the San Mateo County Human Services Agency, Center on Homelessness. And for those of you not familiar, our agency works alongside your agencies as a funder through county contracts, and we play a role in implementing the county's strategic plan on homelessness. So I wanted to start off today by thanking you all for attending, and thank you all for the hard work you do for community members experiencing homelessness. And in the middle of a pandemic, to top it off, we're fortunate to have Homebase facilitating this training and to have legal aid speaking to share with you about tenants' rights. We're excited for this training and hope this can be one of the many tools in your toolbox when working with people experiencing homelessness as they search for and move into housing. So with that, I will hand it over to Homebase.
Great, thanks, Leah. And thanks, I see folks are still hopping on, so you'll probably notice, but as you're hopping on, and if you can just put your name and your agency and your role over in the chat boxes, would be great. So like Kalia just said, I'm Lily from Homebase. This is my husband in the background. We work in a closet together. And Monica, my colleague from home as well, here today. Just a couple logistics before I introduce our speaker and we get started. Just letting you know that today we are going to be recording the training. If you have any concerns about this, feel free to reach out to me or Monica in the chat. And other logistics, I know this is all, you all know this like the back of your hands, but if you can all make sure that you're on mute unless you are meaning to speak. So you don't do things like make everyone listen to your 4-year-old crying like I'm doing right now. And then feel free to use the chat function as much as you want for questions. You can, again, you can direct chat me and Monica if you have questions about anything about tech. But feel free as David's talking, that we will have points where we're going to do Q&A kind of stuff. But since there's a ton of material to get through, please do use the chat function and we will try to keep track of stuff there to make sure that we get your questions answered. If there's anything really specific about a really specific client issue you're having, David is happy to talk with you all about that, but probably not in the context of the training. So you can definitely reach out to him after and he'll provide his contact information. And lastly, we scheduled 2 hours for this workshop. We have it planned to be 1.5, but we just did the 2 hours to have a little padding. So best case scenario, you'll get a little bit of time back, which on a Friday, I'm sure no one will object to. So without too much further ado, I want to introduce you all to David, who's with us today to tell you everything you needed to know about tenants' rights. David's an attorney. He's been doing legal aid work for over 20 years. He's worked at Bay Area Legal Aid, the Law Foundation of Silicon Valley's Mental Health Advocacy Project, and he's now been at the Legal Aid Society of San Mateo for the past 10 years. So we're super, super happy to have him here. And before I turn it over to him to start the presentation, I wanted to ask you all, now that your fingers are limbered and warmed up in the chat box wanted to ask you just to go ahead and take a minute to type in any issues of particular interest or areas around tenants' rights where you have specific questions. If there's anything that we're really looking forward to hearing more about today or stuff that keeps coming up for you, and that'll just give David a sense of sort of areas that might be sort of particularly urgent for you all to hear about. So we'll just go ahead and take a minute for you all to think about that and to go ahead and put a couple thoughts into the chat box if you have them. If not, he'll go ahead and just give you the rundown, but again, it's always helpful to know if there are particular areas that are coming up for you.
Thank you, Lily. Thank you, Kalia. Thank you, Monica. And hello, everybody. Thanks for joining us this morning for our training. I just wanted to say hi, good morning. Appreciate so much all the work that you do. I like to say that our job, our mission is to prevent people from becoming homeless. And that, to me, that's the best way to prevent homelessness. But I know all of us are involved at various stages of people struggling with their housing issues. So appreciate all the work you do and look forward to working with you this morning. I'm gonna try to leave the screen and share my PowerPoint screen now. And get into, get into share mode and slideshow mode. Can everybody hear me okay? Can anybody hear me okay?
Yep,
Yeah.
great.
Got the, thank you. Got the thumbs up. Forgot you're all ordered to be on mute. All right, please jump in with questions in the chat or as necessary. I'll try not to just talk at you for an hour and a half, but try to make this interactive to a certain extent. So anyway, our contact information for Legal Aid Society of San Mateo County is on the first slide here, and it's a couple other places as we go through this. But what we're going to cover today, we're doing today, and we're also doing next Friday. So next Friday's focus is more on fair housing discrimination, particularly with people with disabilities and accommodations for people with disabilities. But today, we're covering just a quick intro to what we do here at Legal Aid, types of tenancies and housing that are out there, because the laws change depending on types of tenancies and housing. We're going to cover evictions, including the laws that have been passed recently, related to the pandemic. And then we'll cover a few other popular topics at the end if we have time, like privacy and Section 8's habitability and a little bit on fair housing. So just a little bit about what Legal Aid Society of San Mateo County is about. We've been doing our work for over 55 years now. Our mission is to help low-income people, particularly with basic necessities of life, like housing, income, access to healthcare, freedom from violence. And we do that through the enforcement of civil legal rights, as opposed to, we don't do criminal law, we do civil cases. So our practice areas include housing, landlord-tenant mostly, public benefits, access to healthcare. We have a teen parents program, usually involving domestic violence cases or immigration. We help kids with special education, families with special education. And we have an attorney who does focuses just on seniors, mostly freedom from elder abuse for the seniors, though also some consumer law for the seniors. We do not do divorces. We don't do consumer law except for the seniors. We don't do bankruptcy cases. We don't do personal injury cases. So if people call us, we refer them to other places for those types of cases. You can always refer anybody to our main phone number, and if they might have a legal problem, even if it's not what we do, and we'll try to figure out what the best referral is if you don't know a better referral than us. So don't worry about over referring people to us. We'll deal with whoever comes to us. Let's see. So we have a housing rights unit here at Legal Aid Society. I'm an attorney in our housing rights unit. We are currently 4 attorneys and 3 housing coordinators, and we're trying to hire someone to help with rental assistance coordination. We're going to have access to some rental assistance funds, along with, I know some of your agencies also have rental assistance funds, and a lot of that is going to be needed now, and a lot of it is going to be needed coming up in the next couple of months. So, so our job, like I said earlier, in our housing unit is to prevent homelessness when we can, and we do that through legal representation in court cases or other advocacy, pre-eviction advocacy. We do advocacy related to Section 8 voucher holders. We do advocacy regarding fair housing laws, housing discrimination, including accommodations for people with disabilities. And we advise on just about all landlord-tenant issues that involve, helping people maintain stable, healthy, affordable housing. The bonus service I offer to all of you today for tuning in. You can call me anytime for free advice on your own personal landlord-tenant issues. From time to time, people I work with out there, they're renters also. I know you guys all work tirelessly for your clients, and once in a while we have our own issues. And so I have no problem with you calling me if you want to talk to me about your own personal issues. I will make time for you happily. So moving on to the next slide, maybe. I am hitting advance and I am not advancing. So let me see what to do with that. We were practicing and we got hung up here before. So what I did is I stopped and then I started again. So let's try that again. Not sure if this is operator error or computer. All right, we successfully moved on. Let's. I want to start with a little quiz. During the pandemic, there's a lot of misperceptions. There's a lot of myths flying around out there. So I just want to start off with a little quiz about some of the myths, and I think Monica might help us do this in the form of a poll where you can answer the questions yourself. We're going to get a little interactive here. Monica, let me know if we have a poll that's gonna, I don't see it on my screen. But these are the questions, true or false questions, start off easy. Number one, true or false, tenants cannot be evicted until 2021 because of eviction moratoriums. Is that true or false? Number two, is it true or false? Tenants who lost their jobs due to COVID-19 this past year, they do not owe rent for March through September of this year. And I think Monica's telling me that we're okay. There, you have your poll. Question number three, President Trump shows up at your door with a couple of soldiers and tells you they need to stay in your home because Mar-a-Lago is underwater and New York City has no vacancies. You have to take them in and quarter them. Is that true or false?
So folks should be seeing a poll on their screen. I'm seeing some answers come in. We're at about 70% responses. So we'll give folks another couple of seconds and then we'll close out and share.
Thanks, Monica.
Thank you. And we might be having some technical difficulties. I'm not sure if folks are able to see now that we're sharing the results, but I'll share them verbally just in case. For question one, we had 73% of people answer false, 27% answered true. For question two, we had a similar breakdown, 73% answered false, 27% answered true. And for question three, we had a little bit more of a leaning. We had 93% of people answer false and 7% answered true.
All right. Thanks, Monica. So let's see. Stop share results. Sorry, everybody. Again, it's not advancing when I'm asking it to advance. I'm not sure why this keeps happening.
If you'd like, we can try to share and then advance on your queue. I'm not sure if that'll help, but we could try it.
Yeah, how about we do this one more time, and next time we'll go to plan B, so we don't have to torture people with restarting every time. All right, so the answers to the questions, they are all false. That's true. All my questions are trick questions, so if you didn't get it right, it's because I was trying to trick you. If you did get it right, good job. Number one, tenants are actually being evicted now. There were moratoriums There are still some moratoriums. It's very complicated. So some tenants are protected, but some are not. There are some tenants that are actually being evicted right now. We'll get into more of that later. Number two, again, a trick question. The tenants who couldn't pay their rent for certain periods earlier this year that we'll cover in detail, they owe the money to the landlord still, but they cannot be evicted for paying certain amounts. So, that's the answer to number two. And number three was just a silly question as we hopefully say goodbye to our 45th president on the way out the door. Now let's see if my slide will advance. Yay. All right, so let's get into tenants' rights. And I like to start by covering certain types of tenancies and types of housing, because the laws change and are affected by the types of housing and types of tenancies. So a fixed term tenancy is what we call like a lease, like a 1-year lease. It's like the tenancy is locked in for a certain period of time. A 1-year lease is common, but it could be 6 months, could be 9 months, could be 1.5 years, could be 2 years, could be less, could be longer. But a 1-year lease is common. It's almost always in writing. And again, the point is that it locks the tenant and the landlord into certain things. The landlord can't evict the tenant unless the tenant seriously breaches the lease. And the tenant can't get out of the lease early without certain negotiations or certain penalties. And importantly for the tenant, the landlord cannot change the rent during the term of the fixed term tenancy. So those are common. But what often happens is the fixed term tenancy ends after like a year or whatever, and then it automatically becomes a month to month if a new fixed term tenancy is not entered. So we see a lot of month to month tenancies, or sometimes landlords and tenants just enter in from the very beginning into a month to month tenancy. And then in that case, the tenant and the landlord are not locked into terms. They're just protected by whatever the laws are. So a tenant can terminate a month to month tenancy with just 30 days notice to the landlord. Landlord can change the rent or change other terms of the tenancy with either 30 or 60 days notice, depending on what the change is. And the landlord can terminate the tenancy with 30 days notice for a tenancy that's less than a year old, or they can terminate with 60 days notice for a tenancy that is more than a year old. So those are the most common types of tenancy. I like to mention a little oddball that comes in handy from time to time. It's called a tenancy at will. And basically the concept is somebody who's living in the home with the consent of the landlord or owner becomes a tenant. If they're there, usually they're there for more than a month to become, then they have what we call a tenancy at will. And then they have the rights of a tenant. And the common misperception is, well, if there's no agreement and if the tenant's not paying rent, then they can't be a tenant. And that's actually not true. You don't have to have an agreement. It could be just implied because the landlord allowed the person to live in the home or allowed them to stay in the home longer, longer than a month. And the other common myth is you don't have to pay rent to be a tenant. That's not guaranteed. And then just the caveat to that is, of course, not all occupants become tenants that are entitled to tenants' rights. It always comes down to a case-by-case basis on the circumstances. Thanks, Teresa, for your question. Section 8 tenants are entitled to 90 days notice. The non-Section 8 tenancies are the 30 or the 60 days. But you're right, Section 8 tenants get a 90-day notice. That's a special rule for Section 8 tenants. So thanks for pointing that out, Teresa. Let's see if I can move on to the next slide. No, here I go again. So if I hit stop share and share and share. Now I'm back at the beginning. Sorry, everybody. Now I'm
Great. It gives us a chance to reflect.
All right. So those are the types of tenancies. And I want to mention some of the most common types of housing. And again, it's important because there's different laws and different circumstances and different dynamics for the different types of housing out there in the world. There's, what's common is the private market rate housing, the market rate apartments. An ADU is an accessory dwelling unit. You might have heard that term. You're going to hear more of it because there's going to be more ADUs in the future as we need more housing for people. But that's like an in-law unit, or like a basement that's converted into a living unit is called an accessory dwelling unit. Or there's private houses for rent, of course. And then the rent is whatever the market is, whatever the landlord and tenant agree that it is. But there's a lot of other types of housing. There's federally subsidized, privately owned buildings. There's federally subsidized public housing, not a lot in San Mateo County. San Mateo County relies more on Section 8 vouchers for subsidized housing and the federally subsidized private units and the BMR units. But you go to other places and there's a lot of public housing in some places. There's Section 8, Section 8 voucher holders in San Mateo County. It's called the Moving to Work program, is the most popular voucher program here in our county. It's still like a Section 8 program, just got some special rules. Do we have anybody from the Housing Authority in the audience here today? I don't remember seeing anybody.
No, I don't think so.
If you're here or not from the County Housing Authority, I just like to say we're lucky in San Mateo County to have a housing authority that's very well run for the most part, as far as I've seen. So I always like to say thank you to the Housing Authority workers. What we do see a lot of in San Mateo County and more is coming below market rate housing, what we call BMR housing. So it's private rental units, but the rents are set at below market rate, so it's affordable. Unfortunately, it's not as cheap as like federally subsidized housing. You still need like a moderate income to be able to afford those places usually. Low-income housing tax credit properties is one example of a BMR program that we see frequently. They have their own rules. Mobile homes have their own whole section in the law books for mobile home. Mobile homes tend to be more affordable for people, so it's a common source of affordable housing. People renting, one room, one bedroom in a house that's shared with other renters. We seem to be seeing that more and more, right? Because that's another affordable option for people. And then that presents its own challenges when you're sharing the home with other people. There's rent control jurisdictions, although in San Mateo County, we only have East Palo Alto as the only city with rent control, a full, municipal rent control system, versus we're going to talk about the state's rent cap in a little bit. And we've seen, and the other, I just mentioned at the bottom here, former owners of homes or tenants in homes after a foreclosure takes place. We saw that a lot after the meltdown in 2008. We saw a lot of foreclosures. I'm a little concerned that we're going to see that again, so I've left it here on my slide. So that's a long-winded list of types of housing, but it's important because the type of housing, again, controls the type of laws that apply and situation the tenant's going to be in and how susceptible they are to being evicted. I don't get it, but I am frozen every time I try to go to the next slide. Stop share screen. Slide. Try something different. All right, so let's start getting into what we're curious about, and that is The new laws, the relatively new laws, tenant protection laws, have really done a lot to help tenants in the past couple of years. And starting with the Tenant Protection Act of 2019, we call it the TPA, Tenant Protection Act, passed last year at the beginning of the year. So it's pre-COVID. It wasn't passed to address COVID. It was just passed to address the crazy rents that tenants have to pay in California. So it's a statewide law, and it does two things. And you've probably heard this now, but we'll cover some of the details. It caps the rent increases for tenants, and there's a formula for the rent increase. So it's 5% plus the consumer price index, whatever it is for that year. And that equals somewhere between 6 to 9% as a cap for the rent increase. And no matter what the consumer price index, there's a 10% max rent increase for tenants who are in place. Now, when the landlord re-rents the home and it's a new tenancy, then they can start over with whatever the market is. But once a tenant is in place, they're now protected with the amount the landlord can raise the rent each month. So I call it a rent cap, rent increase cap. It's not full on rent control. Landlords will call it rent control because it does control the amount of rent they can get ultimately. In 2020, the current rate is 6%. There's a cap at 6% in 2020 because the CPI was only 1%. So it was 5 plus 1. 2020, it's 6%. In 2021, we're not sure. I don't think the rate of inflation is too high because of the stagnating economy, because of the pandemic. So I don't expect the rent increase to be more than, much more than 6%. I'd be surprised. Let's see. So the second thing that the TPA does is it requires landlords to have good cause to evict the tenants. So whenever you have any kind of rent control, you have to, or rent cap increase, rent increase cap, you have to have good cause to evict the tenant, or else the landlords would just evict the tenants every time they wanted to raise the rent. So that system doesn't work. So they go hand in hand. So now landlords covered by the TPA have to have good cause before they evict the tenants. There's two types of good cause to evict. There's what we call at fault good cause. That's where the tenant does something wrong. The tenant breaches the lease, tenant breaks the law, tenant causes some trouble, and the landlord wants to evict them for that reason. And then there's no fault good causes, or what we call, landlord's business reasons for wanting to do an eviction. Landlords can evict for things like they want to move in a close family member, or the landlord wants to sell the property and maybe cash out or flip the property or whatever. If those are legitimate business reasons, landlords can evict for those reasons also. So that's the Tenant Protection Act in a nutshell. It does not cover everybody. We're going to go to the next slide and it's going to get complicated. I forgot to mention the rent increase cap is that's the increase for 12 months, for 1 year. So once every year, well, you can do 2 increases, but the maximum can't be more than the increase. So I'm going to go to the next slide. Of course, I'm not. Monica, are you able to advance the slide, or do I need to get out of mine?
I'm not able to advance it, but if you'd like to try stop share, and then I can share on my side, and we'll see if that works. We'll try plan B.
Thanks. Apologies, everybody, for the technical. I don't know why that's true. Monica's going to bail me out here.
Is that looking right for you?
Yeah, thank you.
Great.
All right, so the Tenant Protection Act gets a little complicated because it doesn't apply to everybody. You know how laws are made. The tenants want protections. Lawmakers wanted to protect tenants, but the housing industry didn't want to give them everything. And so you end up with these compromises. And so Tenant Protection Act covers some tenants, but not all of them. So the rent cap, the rent increase cap applies to the most common rentals like apartments, but there's exclusions. And some of those exclusions are houses or condos, you know, the owner owns just that house or the condo. Duplexes, if the owner is in the second unit of the duplex and the tenant's renting the other unit in the duplex, TPA doesn't help you. If the building is less than 15 years old, the TPA doesn't help you. So those are a few of the biggest exceptions. The good cause to evict requirement also has exceptions. Again, they're similar, doesn't apply to houses or condos, doesn't apply to the duplexes if the owner's in the second unit, the less than 15 years. It also doesn't apply where there's an owner occupied home and there's 2 tenants or less renting on the same property, and that includes the in-law units or the accessory dwelling units. So there's still some significant exceptions to the rule that tenants, you know, aren't protected. Another one is if you want to be protected by the good cause requirements, you got to be in the home for more than 12 months. So new tenants that have been there less than a year don't get the protection. And then one benefit to the tenants, though, is if the landlord is doing a no-fault eviction for a tenant that's protected under the TPA, they get relocation money, which is equivalent to the landlord has to waive the last month's rent. So these tenants get that if they are being evicted for no fault. If you're getting evicted because you broke the lease or you did something wrong, then you're not going to get the relocation money. Next slide, Monica. Thank you. All right, so let's see if we see how we did with the first section. Let's get a little interactive again. We're going to do a quiz, a couple of questions. We're going to set this up with a hypothetical situation. We got our tenants, Juan and Sylvia, renting an apartment in San Bruno. Their rent is $2,000 a month. Their landlord gives them a notice to increase their rent up to $2,500 a month. Juan and Sylvia are not happy. They protest the new amount, which is a lot for them, a big increase that they can't afford. Of course, the landlord response is, if you don't like it, you can move. In fact, here's your 60-day eviction notice because you're complaining about my rent increase. So here, you're going to move. I'm kicking you out in 60 days. Juan and Sylvia come to see you. They're worried they might be homeless if they get evicted. So that's the hypothetical. Questions are on the next slide and probably on a poll in front of you. So we got 2 questions. Number 1, can the landlord raise the rent $500? And the second question, can the landlord evict these tenants, Juan and Sylvia, under the Tenant Protection Act? So I'm going to give you about a minute to answer those 2 questions or see how it comes in.
Great, and we're at about 30% participating. Let's see if we can get up to 50 and then we'll share the results. And if at any point you're having any technical difficulties or can't see the poll, feel free to send a chat to me or Lillian. We'd be happy to assist. Give folks another 5 seconds here. And are we able to see the results?
I can see them.
Okay, great. I'll turn it back over to you, David.
All right, thanks. Why don't we go to the next slide and we'll look at the answers. And I'm gonna turn off that screen. All right, so again, my apologies to everybody. Every question is a trick question. If it wasn't, then I wouldn't have a job. So the answer to the first one is the tenancy is TPA protected because it's an apartment, and apartments are covered on the TPA. But the rent increase is 25%, so it's more than 10%. So it's too high in 2020 because the rent cap is 6%. And even if any year it would be too high because it's more than the 10% max. The being in the home for a year only applies to the good cause requirement, not to the rent increase requirement. So they get the protection of the TPA no matter how long they've been there. Now, somebody might say, wait a minute, what if their apartment's less than 15 years old? Then it wouldn't be TPA protected. You'd be right. I didn't put that in the hypothetical. So C, again, a little bit tricky. Oops, did I just advance that? So technically C is the correct answer because it's only a TPA protected apartment tenancy if they've been in their home longer than 12 months. So if it's TPA protected, then the right answer is A, the landlord does not have good cause to evict them under the TPA. And some of you answered D because you know that landlords cannot retaliate against their tenants for speaking up for their rights. And so you're not wrong if you selected D. So overall, good job. And we can move on. All right, so we had the Tenant Protection Act of 2019. Us tenant advocates were happy. We finally got, a victory for the tenants. Probably had some protections. The playing field was leveled a little bit more, helped the tenants out in a difficult rental market. And then what happens? Boom, the pandemic comes along. COVID-19, coronavirus hits early 2020 and wreaks havoc on everybody, including tenants and low income and moderate income employees and people with jobs that get wiped out by the pandemic. Now people can't pay their rent because they're out of work. There's some help from the government with the initial, stimulus money and unemployment benefits. That helps keep some people afloat. But many, many people over the past year have just gotten behind or way behind in paying their rent because of the pandemic. So there were various, moratoriums and partial protections and assistance that kind of got us through the year until September. In September, the legislature finally realized, the California legislature finally realized they had to act, they had to do something significant to figure out what to do with all these tenants and landlords, not getting paid. So California came up with the COVID-19 Tenant Relief Act of 2020. That's a mouthful. So it's known as AB 3088. It was Assembly Bill 3088. So you might have heard it called that. Or we say the Tenant Relief Act of 2020. So what California did, they passed this law that covers rent debt, what to do with all the rent debt that's been accumulating over the past year, and how does it relate to evictions. And so what the law did is it came up with 3 time periods. The first period is what's called the protected period. That's from March to August of this year. March is about when people started losing their jobs. This law was passed in September, so they cut off the protected period, March to August 2020. So if there's rent that the tenant cannot pay in that period, the tenant cannot be evicted for not paying that rent. It converts automatically to what we call civil debt or consumer debt. And what that means is the money is still owed, but the tenant cannot be evicted for not paying it. This is all assuming that the loss of income, the inability to pay, is related to the pandemic, was caused by the pandemic. So if you lost your job because of the pandemic, if your hours were cut because of the pandemic, if you got sick with COVID-19 and couldn't work, if a family member couldn't work, if you have medical bills related to the pandemic and can't afford to pay your rent. That's when this law kicks in to protect you. So then the law was passed in September. So they made what's called the transition period. The transition period was beginning of September through the end of January next year, January 31st, 2021. They call that the transition period because they made tenants responsible to pay 25% of their rent for that 5-month period if they want to avoid being evicted. So long as tenants can pay 25% of the rent owed for those 5 months, and they can pay it by January 31st, then they don't get evicted. So there's still 75% of the money the landlord doesn't get, still 75% the tenant doesn't pay, but the tenant does not get evicted for not paying that 75%. That becomes consumer debt also. And I got a chart on the next slide we'll get to in a minute or two that maybe helps illustrate it visually a little bit better than just in these words. So there's a protected period, then there's a transition period that goes through next January. Now we're middle of December now, so that's just a month and a half away. So when February comes along, we have what I call the uh-oh period. That's not in the Tenant Relief Act. That's not the legislature's words. That's my words, the uh-oh period. Uh-oh, because starting February next year, a month and a half away, tenants need to pay their full rent or else they're going to get evicted. Right now, that looks like trouble because the pandemic is not going away. It's not getting better. In many ways, it's getting worse. And so it's getting harder and harder for people to get their jobs back. So we're not sure what's going to happen in February. There could be new laws enacted by then, but we don't know. We'll see. There are lawmakers that are working on this, and there's landlords that aren't happy because they haven't been paid rent for nearly a year. So there's balances that they're trying to strike. So the last note at the bottom there reminds everybody the protections are only for tenants who lost their income because of the pandemic. And they have to submit an AB 3088 declaration. And I'm going to show you a little bit more what the declaration is. Basically, the declaration is a statement under penalty of perjury that you can't pay your rent because of the pandemic. But for now, let's go to the next slide. And we'll see a visual representation of the different periods, the protected period and the transition period. So so yellow is what we call consumer debt, non-evictable debt. So from March to August, it's all yellow. All of your rent debt for that period you can't be evicted for. Then we get to September through January, and you've got the green section where it says eviction rent debt. That represents the 25% of rent the tenant has to pay, or else they get evicted. And someone else did this slide and they made it green. I think they should have done it in red because it's pay it or else. But the other 75% is still yellow because it still converts to consumer debt as long as you pay the 25% of eviction rent debt, the 25%. And you only have to pay it by the end of January. So one of the misconceptions is that each month you have to pay 25% or else. That's actually not true. You just have to pay the total 25% for the 5 months by the end of January. And that's important because landlords have the misperception that they're entitled to 25% now. They're not entitled to it until January. Now, if tenants can pay 25% each month, it's always better to make payments. You don't get stuck at the end with the full 5-month amount. Now, February is all green, should be all red, because come February, you got to pay all of the rent or else you'll face eviction and none of it converts to consumer debt. All right, so we'll go to the next slide. And the next slide, we're going to see, so to get the protection of AB 3088, Tenant Relief Act, you have to sign the Declaration of COVID-19 related financial distress. Put your name on it, put your address on it, read through these statements. It says you can't pay your rent because of one of these 6 reasons, all pandemic related. And then you sign it under penalty of perjury. You swear that this is true. You swear this applies to you. I believe there was a question in the audience, and I appreciate the question, was does this apply to help tenants who are undocumented? And I guess the answer is yes. This law doesn't distinguish between your immigration status. If you're a tenant, and the laws have gotten better over the past few years protecting tenants regarding their immigration status. It's pretty much, California's pretty much made it irrelevant in the landlord-tenant situation what the immigration status is. Landlords aren't supposed to worry about immigration status, not supposed to ask about it, not supposed to discriminate because of immigration status. What matters is can the person pay the rent? So as far as I know, that this law would protect people regardless of their immigration status. Having said that, if your immigration status is in question, you always have other issues, other legal issues that can come up and can cause you problems. But this specifically should apply to anybody and to protect tenants from not being evicted. Okay, what's on the next slide, Monica? Are we up to our next? Oh yeah. So again, like we started off with the training, evictions are happening now. Pandemic protections that we've been talking about don't prevent all evictions. AB 3088, Tenant Relief Act, is mainly here to protect tenants who can't pay their rent. It doesn't stop evictions for good cause, but it does add some protections to tenants. Again, this is where it gets complicated, so don't worry about getting bogged down in the weeds. But for the time being, until February, all evictions are treated as if they're TPA protected. So there's no exceptions right now. And so landlords have to have either a no fault cause, like the owner wants to move in, close relative is moving in, or if there's serious habitability issues that need to be repaired, landlord might have to evict for that reason. Or if the property is sold and the new owner wants to move in, eviction could happen. And if there's serious lease violations, at fault causes can still result in evictions. The cases that we're working on right now, the cases we're seeing right now, are mostly not non-payment because those tenants are protected. What we're seeing now is the landlords who are alleging that their tenants have done serious lease violations. I'll mention at the bottom, my note here, you might have heard of the federal CDC, Center for Disease Control, passed an eviction moratorium, a nationwide eviction moratorium that is supposed to prohibit eviction through the end of this year. So through the end of this month, December 31st. Again, doesn't apply to everybody. There's exceptions, but it's one more tool that we try to use to try to stop people from being evicted, at least until the end of the year. All right, now we go to the next slide. I think we might have our next quiz, if I remember correctly. All right, so we have a hypothetical situation, and our hypothetical tenant is Jamil. Jamil rents an accessory dwelling unit. It's behind his landlord's house, and he pays $1,600 a month rent. Jamil lost his job in the restaurant in March due to the pandemic. So then he tried driving for Lyft, but he was only making about half as much money doing that as his previous job. So as a result, he doesn't have as much income now. So he's been paying half of his rent. So he pays $800 a month. He did that from April to August of this year. So April, May, June, July, August, 5 months, he paid the $800 instead of the $1,600. But then poor Jamil's having a rough year like everybody. He got COVID, he was out of work, he had medical expenses to pay, and he just couldn't pay any of his rent starting in September. So September to now, Jamil couldn't pay any rent. So September, October, November, December, there's 4 months where he couldn't pay any of the $1,600. Sorry, you're gonna have to do some math on this one. Jamil's landlord got tired of not getting any rent from him. So he gave him a 3-day notice to pay rent or quit in December, saying that he owes $10,400 and needs to pay it now or in the 3 days, or else he will be evicted. Just realized I threw in another trick to this question that I didn't teach you, but we'll get it in the answers. And maybe somebody who's really up on the AB 3888 will catch it. So go ahead and answer go to the next page, or the questions that are up on your poll. Give you a minute and a half to do some math and see if you can figure out how Jamil's going to get out of this.
Great, and we're seeing a couple of results trickle in. As a reminder, responses to the poll are completely anonymous, and they're really just a chance for us to sort of check for understanding. So thank you so much for participating. We've got about 39% of folks responding. Let's see if we can get to 50. And we'll give folks 5 more seconds in case there's any last responses. 3, 2, and 1. And back to you, David. Are you seeing the results here on the poll?
I am seeing it and feeling guilty about it, because as I read the questions, I realized what poor job I did at covering. Can we go to the, let's see, the questions and then the answers? I guess skip ahead 2 slides to the answers. So can we go back to the answers to cover number 1? So the first question was, what mistakes did the landlord make when he served the 3-day notice to pay rent or quit? And I don't think I covered this because there's a lot of little details and exceptions and new rules, and we just can't cover it all in this training. Landlords now have to give a 15-day notice to pay rent or quit, not just a 3-day notice to pay rent or quit. So if you're familiar at all, you're familiar with 3-day notices to pay rent or quit when a tenant can't pay on time. And now the landlord has to give a 15-day notice. So that was my bad for not teaching you. So if you didn't know that, it's my fault. And the other tricky one for landlords is if landlord wants to try to, evict a tenant for not paying rent, and there's rent owed from the protected period and the transition period, the landlord has to break it into, because there's 2 separate sets of rules and laws, the landlord has to break it into 2 notices. So this landlord put everything into 1 notice, and it should have been broken into 2 notices. So both A and B are mistakes that the landlord made. C was the tricky question. It said the landlord should have just demanded 25% of the rent owed during the transition period, but rent for January hasn't come due yet, and January's not here, so the tenant, so the landlord can't demand all 25% of the rent yet. It's too early for that. So A and B were true, C is not true, so not all of the above either. So question number 2, how much does Jamil need to pay his landlord to avoid getting evicted in December? This is the dirtiest, trickiest question of all, because the answer is D, 0. How could it be possible that a landlord isn't entitled to any money? Only in California, right? Maybe New York City, maybe New York, but only in California. So why is it 0 now? It's because the landlord can't, so A is wrong because the landlord can't demand all $10,400 now. $6,400 is the money owed in the transition period. They can't demand all of that yet, can't evict for that not being paid yet. $1,600, 25% of the rent, again, can't demand that yet. It's not due until January. So landlords don't like it, but right now, if the tenant can't pay rent because of COVID, they turn in the declaration, they can pay 0 until January and not be evicted. So I can't hear you cursing me, but if you are, I understand. And we'll move on to the next question.
No problem. And I think we had a question in the chat as well, David.
Yeah. Let me see. I remember it. Oh, it goes to Section 8 tenants. Very good question. Section 8 tenants pay a portion of their rent. The housing authority pays the balance of the rent to the landlord. Housing authority has continued to make their payments to landlords during the pandemic. HUD didn't run out of money. The housing authority didn't run out of money. Those contracts are still good. So the housing authority made good and has been paying landlords. This is one of those quirky times when Section 8 tenancy was actually a good thing for the landlords, because landlords were at least getting their Section 8 payments from the housing authority during this whole pandemic time. At least that rent has been guaranteed. The tenant is only responsible for paying their share of the rent. So if they've been affected by COVID, then they only have to pay 25% of their share, not the full amount. Yeah, could be a tricky legal question as to whether if the landlord gets more than 25% just from the housing authority portion and nothing from the tenant, is the tenant in violation, or have they covered their 25%? I'll probably get that case in January sometime and figure it out then. But in general, I would, if I'm advising tenants, I'm going to advise them pay 25% of their share of the rent. And if they're Section 8, just 25% of whatever that is. So like their share might be 1,000 and the housing authority pays 1,500. The tenant just has to pay $250 for those 5 months. Thanks for the question, and I think we can move on. All right, we're going to shift gears to, evictions. These evictions are still helping me. Monica, do you show what number slide we're on? It's not.
Let me check here.
Just trying to do a time check for where we are in the process.
Sure. I think we're on 21 of 37. So right over the halfway mark.
All right, it sounds about right. All right, so we're gonna talk about evictions now. How do landlords evict tenants when they feel like they need to or they want to? So it's important to understand eviction is a two-step process. Step number 1, the landlord serves a written termination notice that tries to terminate the tenancy, and the tenancy ends when the notice expires and the tenant has not moved out. But that's not the end of the eviction process. That's not when the tenant leaves, unless they do so voluntarily. The second step is the landlord has to go to court and file a court case. The court case is called an unlawful detainer or, eviction lawsuit, and they have to get a court order. So landlord has to go through the court and get a court order. The court order is taken to the sheriff, and the sheriff is the only one that can lock the tenant out. Landlord cannot be the one who locks the tenant out of the home. So down at the bottom there, it says self-help evictions by landlords are always illegal. It can't be the landlord who's doing the locking out. It's the sheriff who does it by court order. So two-step process. So let's go to the next slide and we'll talk about those steps. So step one, eviction notice. Common notices are 3-day notices. 3-day notices for a lease violation. Lease violations such as not paying the rent. So landlords give 3-day notices to pay rent or quit. But if there's other serious lease violations, landlord can do a 3-day notice to quit. Or if it's something that the tenant is doing wrong, but it's easily fixable and it's not causing too much harm yet, then the landlord might have to give the tenant a 3-day notice to cure or quit, cure the lease violation. Sometimes it's called perform covenant or quit. And what it means is it gives the tenant a chance to fix what they're doing wrong before they get evicted. And of course, now I have the note that tells you that under the current Tenant Relief Act, COVID Tenant Relief Act, landlords have to give 15-day notices to pay rent or quit. So if it's not something the landlord did wrong, or if the tenant did wrong, or if the landlord doesn't want to get into what the tenant's doing wrong, just wants to evict them, they can give a 30-day notice to terminate a month-to-month tenancy if the tenant's there less than a year. If a tenant's in place more than a year, the tenant gets a 60-day notice. And as we pointed out earlier, Section 8 tenants or moving to work tenants get 90-day notices. So those are the most common notices that landlords use. Sometimes there's some different funky notices for various reasons, depending on the housing, but those are the most common ones. Next slide. So again, landlord has to move on when the time runs out and the notice expires. If the tenant hasn't moved out, the landlord has to move on to step 2 of the eviction process. They cannot just lock the tenant out on their own. They have to get the court order. Unfortunately, many landlords still don't get that. We still get a fair number of calls from tenants saying they've been illegally locked out by their landlord. When that happens, the best thing they can do is call the police. Well, sometimes it's the best thing, not always, of course. But the police generally understand that landlords can't evict without a court order, and most of the police will show up and tell the landlord, you can't do that, you can't evict, you got to let the tenant in. Now that's in the situations where it's relatively clear that the tenant is actually a tenant, can prove that they're a tenant. There's a lot of situations where it's a little ambiguous what their tenancy status is, or the landlord raises such a stink that the police decide they don't want to get involved. And of course, any tenant, if they're causing a lot of trouble, or they're perceived as being causing trouble, then sometimes the police might show up and it might get worse for the tenant instead of better. So lockout situation's kind of a special situation. As I say, for any of these, refer them to legal aid, and we'll do our best to help them under the circumstances they're in. But anyway, the second step is the unlawful detainer lawsuit. You get the eviction order. That's filed if the tenant does not move out when the notice expires. The tenant's allowed to stay in the home until the eviction case is over. So they don't have to move out until the sheriff shows up at the door. Now, they usually don't want to get to that point, but the point is they have the legal right to be in the home while the case is pending. We can go to the next slide, Monica. So I'm just going to go through how the unlawful detainer process works. I mean, somebody shows up at your office with court papers in hand. You know, you can talk to them about what's going on, but hopefully you can get them to us right away so we can start helping them with the legal process. But just the steps of the process, the eviction process are: the landlord serves the notice expires, and the tenant doesn't move out. The landlord goes to court and files the unlawful detainer case in the court. Court case gets served or delivered to, with the court papers delivered to the tenant. At that point, the tenant has 5 days to file a response in the court. Just 5 days, that's quick. We don't count weekends anymore. We used to, but we don't anymore. So now it's 5 business days instead of 5 calendar days. Now the tenant, no matter what the tenant situation is, 100%, I advise tenants to file papers in court, even if they've moved out. Because if you don't file papers in court, you're going to lose the case by default. You lose the case automatically for not showing up, no matter how bad the landlord is. And even if you've moved out, you still want to protect yourself because you could have an eviction on your record if you don't deal with it. So anybody who gets court papers, doesn't matter what their situation is, they need to get to court and file a response within the 5 days. They need to come see us or someone like us, like Community Legal Services of East Palo Alto, and get their answer on file. All right, so after the tenant responds, the case is, live. Then it gets set for court dates. The first court date in an eviction case is called a settlement conference. And that's where the tenant and the landlord and their attorneys show up in court and they try to work out a settlement. Judge doesn't decide anything at the settlement conference. It's all about, you literally get sent out in the hallway at the courtroom and said, go try to work it out. Of course, now we do it by Zoom calls and telephone calls instead of being in court in person, but settlement conferences are still going on. I helped the tenant settle a case yesterday at their settlement conference. If there's no settlement, if the landlord and the tenant can't come to an agreement, then the case goes to trial. In trial, both sides present their side of the story, and either a judge or a jury decides who wins and who loses the case. If the tenant wins, they get to keep living in the apartment, in their home. And if they lose, they're forced to move out. Now, any tenant who loses, it gets to that point and loses, the next thing they're going to ask me is, can I file an appeal? And we've all heard about appeals, but the fact is there's not a realistic option for a tenant to file an appeal that's going to help them. Technically they have the legal right to, but it's not a realistic option for tenants. So, all right. So if the tenant loses, the next thing that happens is the landlord goes to the sheriff with the eviction order. The sheriff brings what's called a notice to vacate. And the notice to vacate is the final warning that the tenant has to move out. Final in quotes though, because at that point, the tenant can go back to court one more time, ask the court for an extension, and that extension can be up to about 30 days. But at that point, the tenant has to pay the landlord to get the extra time so the landlord doesn't lose any more money in the eviction. So that's the unlawful detainer process from start to finish. Quickly, I've got a question that came in the chat, so I'm going to take a second to look at it and see if we can answer it. Caitlin, thank you for the very good question, which is, the tenant is in the home, they get an eviction notice, and then the eviction notice runs out. They're still there because they want to fight the case or they want to work out a settlement. Do they have to keep paying rent after the eviction notice runs out and while the eviction case is going on? The answer is, once the eviction notice runs out, once the termination notice expires, the landlord will not accept any more rent from the landlord. Sorry, from the tenant. So the landlord's going to stop taking the tenant's rent, because if they keep taking it, they're at risk of it being seen as reinstating the tenancy. So the landlord stops taking the rent. So the answer is no. Tenants don't pay rent after the notice expires and while the case is pending. Now, legally, they still owe the money up until the end of the court case. That usually gets resolved through a settlement where it's decided whether the tenant's going to pay any of that rent. Sometimes if the tenant agrees to move out, sometimes the landlord will waive some or all of the rent that's owed. Just, try to give the tenant incentive to agree to move out instead of fighting the case any longer. So I hope that answers the question about rent during the eviction. All right, let's move on to the next slide. All right, so when we have our eviction hypothetical, quiz number 4. Let's see what we have. All right, our tenants are Jocelyn and Maddie. They rent an apartment in Daly City. Their income went down due to the pandemic, and they got behind in their rent payments. So what they decided to do was they decided to sublease a room to somebody else, a third person, and so they could make some extra money to help them pay the rent. Now, the person they rented to, they subleased to, had a dog, so they brought the dog, even though pets are not allowed in the building. So now you've got a sublessee with a dog who's moved in. Now, one day, the dog attacked the landlord when the landlord was trying to serve a notice of rent increase during the pandemic. The landlord wasn't happy about getting attacked by the dog. The landlord served a 3-day notice to quit for lease violations and then filed an unlawful detainer case, which was served on Jocelyn and Maddie, delivered to them on Wednesday, December 16th. So hypothetically, that's next Wednesday. So that's a hypothetical. So let's go to the quiz questions and do your best to answer those questions. See how we do, or see how I did.
And keeping an eye on time, we'll give folks maybe 30 seconds for this one, and then we'll reconvene to discuss. Okay, we're seeing some responses come in. Maybe we'll give folks 5 more seconds. And so now are you seeing the poll results?
I do see the results, and people are doing great on these 2 questions. So let's go ahead and move to the questions slide. Question number 1 was the deadline for filing the response at court. And the answer is B, most people got. It's the following Wednesday, 5 business days. So you don't have to count weekends anymore. So you count Thursday, Friday, Monday, Tuesday, Wednesday. That's going to be the deadline. Courts are accepting new cases, unfortunately. So let's see. Question 2 was, what's the best defense to the case for our tenants here? Yeah, landlords shouldn't be raising rents during the pandemic. So I'm not sad that he got bit by the dog, but that's not the right answer. So deny everything and hope there's no witnesses. That is a defense strategy. So if you said B, it's That is a defense strategy. But it's not a good one. They are in violation by subleasing. Well, most leases say no subleasing. Most landlords don't want tenants subleasing without written permission. I didn't clarify that in hypothetical, but subleasing without the landlord's consent is usually a violation. Having the dog against the pet policy is a violation. So assuming it's not a service dog. So most people got it right. C, this is not a strong case because there are lease violations, and the dog did attack the landlord, which is not a good not a good fact. Dog who's not supposed to be there attacked the landlord, not a good fact. So yeah, tenants should try to reach a settlement with the landlord. Maybe they can make a deal where where they agree that the subtenant moves out and takes the dog with them, and maybe they pay the landlord's medical bills, and maybe the landlord feels doesn't want to evict him otherwise and lets him stay. So maybe a good settlement could be worked out in that situation. So we can move on. And we can move on to the next section. So we covered the new laws, the Tenant Protection Act. We covered the COVID Tenant Relief Act, the pandemic laws, evictions, how that works. We've got about 15 minutes left or so. Are there any questions before we cover a few random topics at the end about what we've covered? Questions about any of the evictions or the TPA or the COVID Relief Act? I just want to give people a chance to jump in now and check my chat. All right, I'm not seeing anything, and that's okay. We can ask questions at the end also. But I wanted to cover a couple topics that come up regularly, probably for you and certainly for us. The first is what we call the tenant's right to privacy. Sometimes it's called the tenant's right to exclusive possession or the tenant's right of quiet enjoyment. And what it is landlords sometimes want to come into the tenant's unit for one reason or another. Sometimes it's legal, sometimes it's not. In general, landlords can only enter the tenant's unit with reasonable written notice. Usually that's at least 24 hours written notice. They can only come in to make necessary or agreed upon repairs or do something, legitimate maintenance to the building or the apartment. Or they can use it, they can come in to show the apartment to prospective tenants or prospective buyers or to contractors who are going to do work and need to inspect, or real estate agents. They have legitimate business reasons for being there. There's a misperception among landlords that they think they can come into the tenant's unit anytime they want for any reason that they want, and that's just not true. And the biggest one is sometimes landlords think they can come in just to do random inspections, to snoop around, to see what the tenant is doing in their unit and what the condition of the unit is. And that's actually not true. Landlords cannot come in, for just to do random inspections and to snoop around. There's a lot of contention between landlords and tenants on this issue. So we get calls, and you probably hear about this one also. The exception for the landlord is they can enter without notice if there's an emergency. If they reasonably believe that the tenant has abandoned the property and doesn't live there anymore, the landlord can actually have to post a notice before they do that, actually, and then they can enter and see if the tenant is actually gone, like it looks like they're gone. But they don't get the tenant's consent because the tenant's gone in that situation. Or if there's a court order that they need to enter for some reason. So this has gotten a little trickier during the pandemic. Tenants don't want any unnecessary people in their homes because it's risk of spreading the virus. So we're getting a lot of calls from tenants saying, do I have to let the landlord in? And right now we think the answer is, the law still applies. Landlords can come in for certain reasons, but they definitely need to take COVID into consideration, which means there should be limited number of people coming into the home, only people necessary to come in. They should practice all the safe practices, social distancing, wear masks, wear gloves, use sanitizer, wipe down, if they touch areas, if they're going to come in, they need to do it safely. So we can move to the next slide. I want to touch on Section 8 because Section 8 is a big program in this county, or what we call Moving to Work program in San Mateo County. Big program for subsidizing housing here. Many of you are already familiar with the Section 8 programs. We won't spend a lot of time here, but in case you're not that familiar with Section 8, low-income tenants get a voucher, and that pays a portion of their rent. And it's, supposed to be proportional to what their income is. And so the tenant pays a part of rent that's affordable in relation to their income. And then the housing authority pays the balance of the rent to the landlord. And Section 8 program here is administered by the Housing Authority of the County of San Mateo. It's part of the San Mateo County Department of Housing. Offices are in Belmont. And there's different types of vouchers. Moving to work is the most common one here in this county, but there's also special vouchers for like people with disabilities, for example, or people coming out of a homeless situation. You're probably familiar with some of these vouchers. Sometimes they're called permanent supportive housing vouchers. Veterans can get a voucher called the VASH voucher. I think the VA and VASH is, I think it's Veteran Administration Supportive Housing or something like that. But the VASH voucher is for veterans, so they can get help paying their rent. It's a really important safety net for low-income residents here in our county. Like I said, there's not a lot of private subsidized housing in this county, and hardly any public housing. So Section 8 vouchers are a big program here. Some of the common issues that Section 8 tenants have is they might need an extension to find a place. Sometimes it's hard to find a landlord that'll take a Section 8. If the tenant does something wrong, they can get their Section 8 terminated. They get rent increases from the landlord, and then Housing Authority has to figure out, the new share of rent for the Section 8 tenant, and that can create issues for the tenant. If a tenant is getting terminated from the Section 8 program by the Housing Authority, they're entitled to a hearing, and they can come see us and we'll review it and see if we can help them with that situation. Fortunately, our Housing Authority here does not terminate very many tenants. It takes a lot for a tenant to get terminated from our Housing Authority, which is, again, is another thing about our Housing Authority, which I think is very good. We can move on to the next slide. Habitability, of course, is a big issue for tenants. Habitability means the condition of the rental unit. Any landlord in California that rents a rental unit to the tenants and makes money off them, they have to provide a livable home. Landlords cannot rent units as is. It can't be code violations and substandard conditions. And the landlord can't say, well, the rent's cheap, take it or leave it. Not allowed to do that in California. The list I have here is a list of common habitability issues that are like required under state law. Effective waterproofing, meaning, the roof and the windows aren't leaking during the rain. Leaking leads to water in the unit. Water leads to mold, and then you have mold issues. Plumbing and gas has to work. You're entitled to hot and cold running water. Have to have toilets that work, that flush, proper sewage disposal. The heater has to work, has to have proper and safe electricity. The grounds have to be, have the trash taken away enough so you don't get rats and cockroaches and stuff. So, you know, trash dumpsters that get picked, trash receptacles that get picked up regularly. You know, things that are safe. The floors, stairways, railings have to be safe so there's not accidents. Front door, you're entitled to have a deadbolt on your door so your front door is secure. You even have to have a phone jack, although who knows if that'll go away with everyone has cell phones now. So that's habitability in a nutshell, just to touch on it for now. And if there's no questions, let's move on to the next slide. Some cities are passing their own local laws, tenant protection. So we're seeing some new local tenant protections. You know, the county a couple years ago passed a law that landlords who allow their place to get run down, and, you know, slumlords, if the tenant has to move out because the landlord, you know, has let the place get run down and there's code violations, and then the tenant has to move out. There's some stronger rules where the landlord has to pay relocation benefits to those tenants who are forced to move because of the condition of the home. So I think the county started, and I think Redwood City and Menlo Park adopted similar. Might be some more cities at this point might have adopted the relocation benefits laws. Redwood City a couple of years back decided to require landlords to offer a 1-year lease to tenants. So one way to help stabilize housing is just to give tenants the option of having a 1-year lease if they want it. The 1-year lease, again, at least it locks their rent in for that year, and they don't get evicted in that year unless they do something wrong. So Redwood City passed a minimum lease term local ordinance. I think another city, some cities are adopting that also. These were passed before the Tenant Protection Act. And so the Tenant Protection Act added some protections. This was when cities were trying to protect tenants before the state came along and gave them more protections. Next slide. So just to touch on fair housing, housing discrimination. Next week, we're going to focus on people with disabilities and reasonable accommodations. But we need to know there's some strong anti-discrimination laws in the state and the federal government, prohibiting discrimination in housing against for protected people in protected classes, and we'll show what those are in a second. We have California has the Fair Employment and Housing Act. That's our main fair housing law, and the federal government has the Federal Fair Housing Act. And there's other laws you've probably heard of that also provide some protections to tenants, anti-discrimination laws. As we said, people with disabilities are entitled to accommodations. Cover that next week. And, you know, what is discrimination? It's treating people differently because they are a member of a protected class. Now, we treat people differently for various reasons all the time, and landlords can treat people differently, for example, based on how much money they have or their behavior or their, you know, past credit record or criminal record. That's what we call legal discrimination. Illegal discrimination is when you're treating somebody differently because they are a member of a protected class. So if we go to the next slide. So it's important to understand that we're talking about landlord-tenant, but the fair housing laws apply to not just landlords, but just about anyone who's in the housing business at all. So it includes the housing authority, government entities that run housing programs, property managers, real estate agents, banks that lend money to buy houses, insurance companies that issue homeowners policies. Just about anybody who's connected to the housing industry is subject to fair housing laws, and it's illegal to discriminate. Next slide. So what are the protected classes? In California, these are the main protected classes that come to mind. Cannot discriminate based on a person's race or their skin color, their national origin, or their ancestry. Can't discriminate based on what they call familial status, which means families with children. Marital status, whether you're married or not, couples that are, whether they're married or not. Can't discriminate based on somebody's religion, based on their sex or gender, based on their sexual orientation, or immigration status. So these are the main protected classes under California and the federal anti-discrimination laws. So next slide. I have a question coming in, and that's a discrimination question. It says, what about family size? Can you discriminate against family size? That's an excellent question. And basically the answer is there are limits. So I think what the question is, if a tenant can a big family, rent a certain size apartment or house, or can the landlord limit the number of people who live in their rented property? So landlords are allowed to limit the number of people in their homes, but only to a certain extent. The general formula that we use is 2 people per bedroom plus 1 more person. So for a 1-bedroom, the landlord can limit a 1-bedroom to 3 people. For a 2-bedroom unit, they can limit it to 5 people. For a 3-bedroom unit, they can limit it to 7 people. But they're not allowed to restrict it more than that, or else it's considered a familial status violation, because families, with big children or families taking care of their parents living with them can be excluded from housing if you have strict restrictions. Like if you say only 2 people in a 1-bedroom unit, now a family with 1 child or 2 children can't rent that unit. So that's considered a familial status violation. So excellent question. Thanks for pointing that out. I've gone through all the slides and the material I wanted to cover today. It's a little bit over the 90 minutes. So clients come to you and they need legal help. We're here to help. We have a housing intake line. The number is on the slide there, the 8911 number. Anybody with a housing problem can call that intake line. We have 3 housing coordinators or more. Sometimes we have volunteers helping us out, and call that line. Sometimes you have to leave a message. Someone will get back to them, and we'll do what we can. And if they have a serious problem, one of our attorneys will take it on. If it's not a housing problem, we also have them just call our legal aid's main line, and people can get a referral to either something else that we help with or referral to another agency. If you ever have a question, if you ever have a client and you have a question, do not hesitate to call me directly or email me or text me directly. There's my contact information on this slide. Or like I offered earlier, if you have your own questions, I am happy to talk to you. Always happy to work through problems our clients are having, try to get them help. The sooner we get them the help, the better usually, right? And prevent homelessness. As you know, the last thing I have here, don't give tenants, clients my direct line. That's not good for them. I might be out of the office for a week, and then they might need immediate help. So they should call our housing intake line to get immediate help and immediate attention, which they might not get if they try my personal line. Plus, they'll be jumping the line ahead of other people who have called before them. That's not fair. So I think that's all I have. I really appreciate your attention and your good questions and your answers to the quiz questions. And is there anything else?
Thank you so much, David, and thank you everybody for joining us today. This was super informative. I've heard so many tenants' rights trainings, and every single time I'm taking notes. So always more to learn, especially right now. And we appreciate everyone's participation. And again, David, just thank you so much for all the information and for being such a willing resource for us on all professional and personal fronts. We hope everybody, and thank you to HSA, of course. We hope everyone will be able to make it next week for part 2 of the Tenants' Rights Workshop. We'll be talking about reasonable accommodations and diving into that a little bit more deeply. So have a really great week. And yeah, don't hesitate to reach out to us. Oh, we put the survey for you all in the chat box. It really does. I think 35 seconds is even an overestimate. So if you can just take 22 seconds to do that, it's really helpful for home base and for our presenters to get feedback from you all. So thanks again and have a wonderful weekend.
Thank you.
Yes.